All right.
Good afternoon, everyone, and welcome to this meeting on the Committee of the Revision of the Penal Code, which is now in session. I'm Mike Romano, Committee Chair. Thank you to everyone who's joining us today, especially in these current circumstances. This is our fifth committee hearing of the year and our fourth over Zoom. Before we begin, I'm going to take a quick roll call in alphabetical order. Senator Burton, I don't think is here. Judge Espinoza.
Present.
Assemblymember Comlager.
Present.
Justice Moreno.
Here.
Dean Richardson, I don't think is attending today. And Senator Skinner. She will probably be joining us later. But we still have a quorum, and I'm going to proceed. Very quickly, today's agenda has been distributed on our website, but here's a quick preview of what we'll be doing. First, we'll hear from Governor Jerry Brown, who originally proposed and enacted this committee. After Governor Brown, there'll be 3 panels of witnesses and experts who will address today's topic, which is sentencing enhancements. We'll hear from experts on the sheer number of enhancements in California, their impact on public safety and the prison population, the disparate racial impact. For example, over 90% of those sentenced under so-called gang enhancements are people of color. And we'll hear from people directly impacted from long enhancements, including a current prisoner serving a 33-year sentence in CDCR. Finally, members of the public will have a chance to comment after the panels. We expect that to be close to 5 p.m. When the time comes, I'll explain how the lineup for public comment will work in Zoom, but please don't do that now. Also, we'll take occasional 5-minute breaks along the way. So with that, I'm very excited to introduce our first guest today, Governor Brown. This committee owes its existence to Jerry Brown. We are his brainchild, and we would not exist without his support. Governor Brown truly needs no other introduction, but suffice to say that under his leadership as Governor and Attorney General between 2007 and 2019, California's violent crime rate dropped 18% and property crime rate dropped 30%. And at the same time, California greatly reduced the number of people incarcerated by almost 25%. Perhaps this is the best evidence that we can improve public safety and reduce unnecessary and unfair incarceration at the same time. We are extremely grateful to Governor Brown for joining us today. There's probably no one on earth who understands the full scope of California's criminal legal system and appreciates the difficult job that the committee has before us. Governor Brown, thank you for joining us. We're eager to hear your thoughts.
Thank you. And I appreciate the opportunity to share them with you. You do have a difficult job, extremely difficult. It's a tall mountain to climb if you're going to make some real headway on changing, improving, revising the California Penal Code. This thing is a monster. It has been enacted and reenacted and amended, changed over many, many decades. So I think the first point I want to make is the criminal law is a product of many forces, many ideas, many personalities. But at the heart of this enterprise is emotion, fear, manipulation isn't an emotion, but it handles emotion. And if you just look back, if I were to start with my governorship in 75, I could even go back to my father's in 1959. There's been radical changes, particularly speeding up in my first term and then through the 80s and 90s and the first part of this century. Interventions based on a lot of politics, a lot of fear, and a lot of manipulation of fear by various groups. A stunning fact is that there are over 20 initiatives that have in one way or another changed the criminal law. Most of it to a more draconian framework, longer sentences through a variety of means, enhancements, changing when credits are available, and the sentences themselves, minimum sentencing, piling it all on. So this affects the criminal law from arrest to charge, to the prosecution, to the sentencing, to the punishment, whether it be in jail or prison or probation. It has, or some kind of mental sentencing, mental commitment. So this thing is a big, complicated ball here that you have an opportunity to examine, take apart, and look at. That has never been done before. There are some law review articles, very few, I might add, that have looked at this. So this is a very virgin territory. Take a look based on traditional jurisprudence. Taking the goals of the criminal law, and that itself is contested in various ways. But what is the purpose of the criminal law? What do you do when you make something a crime? Who's it a crime against? And what are all the implications? So I don't mean to start a big philosophical discussion, but I think it's so important that thoughtful people, knowledgeable people, take the time and study and reflect and debate what is it that we have wrought in these many decades, we being the people of California through its politicians and through its ballot measure process. So to get to specifics, well, let us take, when we had the indeterminate sentencing law that was around for more than 50 years, and as far as I'm concerned, pretty successful. 99% of the people who were in prison could get to the parole board within 7 years. There weren't enhancements, there weren't credits, there weren't this tax code-like complexity attempting to patch things up when a horrible crime happens to make sure the punishment fits the emotion of the moment. We just had a sentence, you were sentenced to the term prescribed by law. And then this rather remote and distant parole board did the rest. There were criticisms of it, but suffice it to say, average sentencing was dramatically lower. The number of prisons was 12. Today we've got 34 prisons, counting the Stockton facility. They're probably going to close a couple. Nevertheless, if you take the 20,000 to 27,000 under Reagan, the 17,000 to 31,000 inmates under my term, and you then say, okay, what's the population growth? What's the number of absolute crimes that have increased? You're going to find out a total disproportion between the number of prisons, the number of prisoners, and these other statistics, namely population and actually felonies committed. So there's a lot of work there to just wonder, well, how did this all happen? Well, we know it's DAs, it's candidates. In fact, I would say the whole premise of George Deukmejian was to get rid of the judges that I appointed and bring an era of tough on crime kind of thought. It wasn't a profound philosophical reflection. It was more a sensibility bred out of the life experience of George Deukmejian. And then that set the ball rolling. Wilson kept that going, that punitive spirit. Gray Davis certainly embraced that as well. I believe the number of paroles that he affirmed of the parole board was 14, all women. The number of paroles granted relative to the hearings was around 1%. So there we are. Now, so I really want you to take a look at this thing, the concrete, of course, length of sentence, minimum sentencing, enhancements. I think someone told me that there are 400 separate enhancements. So, and then what the short-termers, they go to prison for a year and a half, 18 months. What does that accomplish? You got to look at that. Of course, then that gets you into the question of what's going on at the county level. And counties are not the same. County in which I'm in is Colusa. It is very different than Los Angeles. San Francisco handles its punishment, doling out of punishment and prosecution and charging, very different than Kern County. So we got a complex state. We've got a penal code that does not exhibit reflection, philosophical integrity, or even coherence. So this, I don't think you can do it all. As a matter of fact, I think you're going to have another round of the penal code. Try to accomplish something that you may want to put on the ballot at the next election, but that's not, you're not going to be able to take this whole penal code and make it into a very thoughtful, rational, understandable document. I think the American Law Institute and the restatements of criminal code and contracts and all the rest, those were hard enough, and they didn't accomplish all that much. So you've got to be realistic. What can you do? And I think what you can do, first of all, don't do any harm. Don't make it worse. And that always can happen. But secondly, take a bite into the obvious. I mean, the number of codes, the way behavior has been sliced and diced for criminal description is unbelievable. I mean, the common law had a very limited number of crimes. Are we that different that we have to have 5,000 different sections? You got to make this thing simpler. You got to trust judges, whether you like it or not. You have to create norms, and then judges have to judge. If you try to micromanage, you invite, first of all, complexity. So no one's going to understand the law except a few deputy DAs. But you also invite endless change. When you make it a matter of state law, and then some event happens and people don't think the right punishment is dealt out, they go right to the legislature and they want changes. That is what's been going on. And no matter what the legislature does, they're going to go to the ballot. And it isn't based on thought. When I did Proposition 57, I attended a funeral before it actually went into effect in the San Fernando Valley. And one of the local politicians was denouncing 57, attributing the death of the fallen deputy sheriff to the provisions of 57. Standing in a line of officers and family before the memorial service that takes place every year, one of the Southern California chiefs, as he walked by, he said softly in my ear, "Your policies killed this man." And the son said the same thing. So this is a very emotional business, has a certain amount of power. There's such a bifurcation. You have Black Lives Matter, and then you have a whole group of people like those who are yes on Proposition 20, who do have a sense of the world that our punishment is too lenient. Our sentences are too short. And so you can think of that. I wouldn't dismiss it, but I think there's another view. And if you take a comparative view around the rest of the world, we are really deviant to what has become a world norm. So with that, I think you ought to get at the worst first, because the number of crimes, if you can't get to the crimes, get to the enhancements. If you can't get to the enhancements, get to earlier parole. That is one system where you leave the framework in place, the whole complex mishigash, as I would call it. But then you say, but you can go to a board of experts, of deeply experienced people, and they can evaluate whether you've turned your life around. So I don't know whether you can ever get back to everybody gets to parole in 7 years, 10 years, 15 years. There ought to be some, and there may be different tiers. You might be able to apply for earlier parole. We've taken this old code section and allowing the Secretary of Corrections to send a sentence back to the judge and take another look. And that has no particular restraints on it. It's just is there. We pulled it out of the code and we started using it. It had been basically disused for years, if it ever was. So there's a lot of things you can do. It takes subtlety. This is not the place for a rhetoric and high speeches and the typical politics that you find in the Capitol Dome or out in the hustings here. So, but if you do the wrong thing, then the whole thing can go up in flames. So you can die by fire or die by ice. You can fail by being too timid, or you can fail by being foolishly overextending. So either way, I'm sure I'm going to find some things I'm not going to like. But no matter what, I think if you can, there's a lot to do that you can accomplish. And then you can put something on the ballot, and that's it. So you can do great things and still have room for an entirely new penal revision commission that will have just as much work to do. So that's because you're dealing with this monster called the California Penal Code 2020. And it's just a cornucopia of bad ideas that you can pluck at will and do good just endlessly as you wander through the provisions. And I would encourage you to do that with zest and zeal, but with a certain amount of insight and wisdom. That's what I got to say.
Well, thank you very much, Governor Brown. You and I have spoken over time, and I've had the opportunity to pick your brain a lot. I was wondering if other folks on the committee had any quick questions for you before you left. Senator Skinner?
Governor, good to see you. Thank you for, am I unmuted now?
You're unmuted. We hear you clearly.
Okay. So you gave us some wise advice, but it was broad. And you're absolutely right. We can't be too timid, but if we go too far, we can have terrible backlash. And we see right now with Prop 20, there's people that view 47 and 57 as needing to be corrected, which is hard for me to appreciate, but whatever. So I would appreciate if you had any more specifics you could share. You mentioned the enhancements, you mentioned the number of crimes. Are there any, can you hone in at all on particular things that you, those are broad. Is there anything very specific that you really recommend we look at?
Well, you might take a bite at getting rid of all the enhancements, make it or something very broad in the enhancements. There's so many of them that, you know, we got the gun enhancement to discretionary. You could give the judges more leeway. Right now it's tilted to impose the enhancement. I think you have to, you could maybe make some language to move it in a way the judge would be should be disinclined to put on enhancements. Maybe you could have some language that enhancements are an extraordinary remedy and not to be lightly applied. So that might give judges some thought, and maybe you write the right language. It might allow appellate courts to police that. Certainly earlier parole for more people. We did youth parole up to the age of 23. We did the elderly parole. Why not grab the group in between? Those are two that are right there. So those are, and then, well, I just stop there because I think this thing could be a work of a lifetime because there's so much wrong with the California Penal Code.
Any other questions?
This is Moreno. I would just like to echo, you know, my interest in parole reform. I wrote a couple of opinions on that, really criticizing the regulations that always looked at the circumstances of the offense as a basis for denying parole. And the circumstances of the offense never really change, so there's no opportunity for rehabilitation. You know, I was appointed to the Supreme Court by Governor Davis, who had a dismal record on parole, as you point out. But I think that's one area we could really hone in on, a particular interest of mine, besides the enhancements and indeterminate sentences and so forth.
Well, I think somewhere, and these numbers vary, because if you want to know what's the percentage of parole hearings that result in denial,
Yeah.
A lot of the inmates waive. And so you get maybe 25% waive. And if you don't count the waived hearing, it's, well, I've heard a number as high as 75% denial. That may be too high. But whatever it is, there are. What?
It is that high.
That's about right.
Well, I think, but how you say that, I know there's a little more complexity there. But and I think the parole board thinks they're going as far as they think they can go. But you might want to give them maybe some more guidance there.
Yeah.
I will tell you that when I had literally thousands of names given to me. Oh, I asked for it. I said, search around the last couple of years for people I could commute. And I would like to do that. And so I looked at, they gave me about 300 that, looked pretty good. Even looking through that, I rejected a number. It just seemed so horrendous that I just didn't have the appetite. I found about 150 or so. So these crimes are pretty scary. And the problem is that the inmates, for example, inmates who kill their children or even torture them often do very well in prison. And so I did approve of the parole, but that takes some strong spine there. So there's a disjunction. The younger, less serious criminals are often the biggest recidivists. The killers have a limited experience killing people, and often they can get over that and become excellent parole people. So, but I would look at this thing from a number of different angles. If you want to call me, I can give you continuing advice, because I've thought a lot about this. I approved about somewhere over 5,000 separate paroles. I read every one of those cases. I read the psychological reports. I read the discussion about insight. And so I've looked at a lot of it, and I have thoughts, and I very much enjoy discussing it in a serious way with those of you who want to change it. So I think there's a lot of areas, more parole grants, in this business of the governor. That's a very questionable maneuver, but that again was done by Ira Reiner, and I think maybe George Majan. There are two of them, and that was a Reiner move to get to be Attorney General. It's transparent.
Political.
So political. Well, I'm a politician, and I can tell you, I do a lot of things for political. I didn't get to be governor four times because I put my nose in the air and didn't get down there in the nitty gritty and do what I had to do. So I think you have to operate on a different plane, and then we have to find a way to implement whatever it is you come out with. But I think there's a lot of things you can do. So there's so much wrong that I think you ought to be able to do something, even if you don't think you're doing that much. It could be quite a lot. And I think the parole area there, maybe give guidance so that it will result in more grants. And I think earlier parole, you got guys sitting around there and they can't get out. If they're not under 23 and they're not elderly, you're looking at sometimes, I think, 25 years there. So that ought to be brought down no matter what, get that reduced. And then, of course, you got to go to the ballot with those ballot restraints that were put in by the people.
So
Any other questions you got there?
Yeah, I have a quick question. So a lot of the reforms that were passed under your leadership, Proposition 57, SB 260, the 1170D process that you mentioned, all focused around rehabilitation and redemption and trying to incentivize people doing the right things and drifting back towards more of an indeterminate scheme, which you've talked a little bit about today. I guess my question is, are there lessons from back in the time when the determinate system was put into place that we should keep in mind as we consider some of these reforms that drift back towards indeterminate sentencing ideas?
All right, sure. You could, that smart people do stupid things. I think that's what, and you're smart and you're capable of doing stupid things from my point of view.
Sure.
In fact, there's a whole book written on World War I called Sleepwalking. All of these bright people went into World War I. Well, I don't want to be that grandiose, but at the time of the determinate sentencing, that was a meme. That was an idea circulating around. It wasn't just California, the whole country. And the meme went something like this, that you have to have, there has to be, disparity is a bad thing. If Mr. Jones gets 10 years for the robbery and he's out in, say, 10 years, another guy gets out in 15, that's a disparity. And so therefore we want to make it, we want to standardize it. Well, that desire, which I think came from a good place, then created the whole rigidity. And instead of having a disparity from a parole board that would keep somebody maybe for some untoward reason The allegation was that black and minorities were being kept because the staff didn't like them or something. That was the theory. And there were people that were in a long time. But the question was, did the parole board see something there that was worth keeping them in for a very long time, or was it something else? So the problem was that when we took the subjectivity of the parole board and we put it into the determined sentencing, thinking we corrected it, we just universalized it and magnified it. So the system that evolved was longer and more arbitrary, even though it was very standard. So we took a concept, let's reduce disparity, and we made it into everyone gets an unreasonable, unjust, very long sentence. So I would say you have to be careful, because that's what a lot of people did. And there was only one conservative who didn't like the determined sentencing, and there was one liberal, Alan Cerroti. He didn't like it either. So, but everyone in the middle, all the conventional wisdom, all the smart people, they went along with this. I had my doubts, as a matter of fact, and I'm not going to get into all that of why I went along with it. Some very political and some more conceptual. But I think you got to look at the waves of ideas. Ideas just circulate around, and it's kind of mass psychology, mass hysteria, I would call it. And you can have ideas on the left, on the right, and I think you have this chance to be more discerning through your discussions, through your debate. Come up with real stuff and don't take anything for granted, because they say things. I don't even that matrix that we had, where the parole board would start taking a sentence that was concurrent, and they turned into a consecutive just by fiat, because they put certain little things in. Again, it was all about reducing disparities. It was all about fairness, but it wasn't. It was about injustice masquerading as fairness. So that's what happened under Majan and Wilson and after that. So there's a lot to clean up. And this is not, some mechanical, this is not the tax code. This is a very emotional laden set of norms that go to govern the most excruciatingly fearful and painful outcomes called these serious crimes, and a bunch of smaller crimes.
Well, right. And of course, the magic that you were able to accomplish is that at the same time as you were able to implement these reforms and bring down the prison population by such a large degree, we saw a historic drop in the crime rate at the same time, which is something that obviously all of us care very strongly about, and trying to find that sweet spot of being able to reduce unfair incarceration and improve public safety at the same time, I think is what, certainly is top of my agenda. Before I let you go.
Let me just say there about the crime. We don't know why crime goes up, why crime goes down. I mean, I was trying like hell as mayor to drive the murder rate down in Oakland, drive the crime rate down. It just kept going up and up till I finally got out of there and ran for attorney general. And I was very concerned that people would notice that. Well, they tried to, but it didn't work for my opponent. But anyway, then the crime rate started going down after that. And I was trying to be pretty aggressive. I don't even want to tell you all the techniques that are now not thought of as so good. I really wanted to get that crime rate down, but the crime rate went down anyway, went down later. So I think you need a pretty rational foundation here for what is the role of prisons in terms of the crime rate. And that's why the conservatives came along and said, well, at least they incapacitate. Whatever else they do, if he's locked up, or she's locked up, they're not going to do anything. So, but crime rates, that's right now they're down. They may start going up again. So anyway, it's changed, and you got to do what you can do in this mood. And I think in this mood, you can get some stuff done through the legislature, and I think even at the ballot. I think you have a very unique window, and it may close. So I hope so. Assemblymember Kamlager, I saw you had a question.
Yes, it's very good to see you, Governor Brown. I'm always sorry that when I came in, you were leaving. But thank you for being part of this. We've been talking a lot about parole. I mean, we've talked about funding. We've talked about sort of AB 109 and realignment. We've talked about sort of the life cycle of a sentence and a defendant. And there's so many interdependencies that lie in the penal code, you know, the relationship that a defendant has with a court, with the prison, with the parole officer, et cetera. I was wondering if you could also give us your thoughts on, you know, other touch points that we could affect as it relates to keeping people actually out of the pipeline altogether. Because there's one thing about like, how do you sort of manage the penal code and lean it out, you know, so that you don't have all of these enhancements. You're not sort of creating stackables. You're not keeping people in the system forever. But then how can we look at the penal code as an opportunity to encourage folks to not even enter into that pipeline in the first place? Because we know that it's philosophical, but you know, you're still creating a space for people to kind of, once they go in, it's very hard for them to get out. So how do we even stop it at the beginning of the spigot?
First of all, it depends upon who's talking. If you're in San Francisco, it's harder to get in that pipeline than if you're in Kern County. And that's not to say San Francisco's right. You know, in San Francisco now, you can shoot up, I've seen people shooting up heroin out of my CHP-driven car. I found that a bit shocking, and I don't think they should let that happen. Now, that gets into the whole idea, what do you do with people? But I think we need more humane, more intelligent actions at the front end. And it's a big mess. I mean, when you look at all the thousands of people in their tents and all the dope and the needles that are floating around LA and San Francisco and Sacramento, it is not pretty. And in some ways, we need more imaginative, but also very stern law and enforcement at the local level, but connected very intimately with mental health and drug counseling and other kinds of rehabilitation educational programs to get people back. But there's no way that you can do away with a certain amount of coercive authority. So I want to just put that on the table. I'm probably for shorter sentencing than anybody around, but I do think that we're not using the shorter sentence coupled with good mental health and drug treatment and whatever at the local level. In one sense, if I could redistribute prison time or incarceration time, I'd put more people in for a shorter time with a better experience, and I would take the people who are in there just rotting away with no production of anything in their lives and move them out the door. So I don't know how you would do that, but you don't want to take on too much, but the local intake is quite a lot. What do you do with young kids who get in these gang-related or these crimes? Yeah, you should give them a big break. Look, when I was governor the first time, we had 10,000 people in the California Youth Authority. The last count was about 600. And now we're shoving it all down to the locals. I don't know what the hell is going to happen with that. I don't think you can solve everything. The intake, a lot is the judges, the prosecutors, the public defenders. There needs to be, I don't think, for example, I don't think local judges, I know we got a couple here, one of them anyway, and the public defenders and the DAs are doing everything they can. I went down and met with the presiding judge of LA several years ago, the public defender and the DA. And at that time, LA was only using the split sentence where they give them probation and a shorter sentence 6% of the time. And Riverside was doing it like 60%. So I asked Jackie Lacey and the public defender and the presiding judge, well, why is this? And, you know, they all said, LA is different. Well, no, I don't believe that. And so the locals have to get wiser and more sophisticated in how they function dealing with this, with various kinds of antisocial behavior. So there's a lot there, but I think you folks want to stick to this penal code because there's enough evil in there. And if you have extra time, you could go down to some of these local officials and you could help straighten them out. Because
but
I think
Governor, I just have to say, I think oftentimes, I can only speak from my experience in LA, folks sort of the default is to charge with a sex crime or a violent crime rather than like really looking at the defendant, the evidence, the case to figure out what's most appropriate, because the default is a longer sentence, a harsher punishment. And we have to, at some point, figure out a way to say that's not okay to just go to that, because it's convenient, quite frankly, and it speaks to what you started off by talking about at the heart of all of this is fear.
Well, yeah, and if you're talking about sex and violence, you just push two buttons, and those buttons are always there. So I think I'll leave that to your wise. Those are tough cases, and the sentencing was less in years past. There's no question. And I don't know what it is. It's probably part of the polarization of our society. But each of these crimes, however serious they are, in times past, there was a lot more room for parole, and I think that it was less draconian. The irony of this society, if I may give you my observation, that we're totally, I don't want to say, well, decadent to some extent. We're very indulgent and very permissive on the one hand. And on the other hand, we're getting very puritanical and outraged whenever it comes to sex or violence. This is part of, we are in a culture, the culture is what it is, and you have to work within it to achieve your goals if you're going to be successful. So.
Finally, I think that Judge Espinoza has a question for you, Governor.
It's more of a comment. Governor Brown, it's time to come back to Los Angeles. There's a lot going on in LA. We just completed a study now known as the Alternatives to Incarceration, with 114 recommendations to the Board of Supervisors to implement a care first, jail last model. And I think it's going to have a big impact on the criminal justice system in Los Angeles County. And I just wanted to mention that a figure that I heard from the director of CDCR towards the end of your last administration, of the 5,000 parolees that came out during your time as governor, the recidivism rate for that population was around 3%. And that number is lost on the public. The public needs to understand that when people are granted parole and the governor doesn't interfere with that grant, the outcomes are pretty good.
They are pretty good.
Quite good.
I would ask you, have you ever heard of a politician who said, I have approved, I've let 5,000 murderers out of prison? You're looking at one right now.
No, I know.
Nobody talks that way. They all talk about non-violent criminals. We're dealing with violent criminals, and yes, sex offenders, and yes, people who treat their children in a horrible way. The real question is what's the crime? And you can have a very horrible act, but what we're seeing now, the culture, and certainly the prosecutors, they like to essentialize an action. So if you take an act or several acts, that becomes your essence for the next 60 years. And somehow we have to be able to say, that was a horrible act, and we're going to do something to you. But what is that something? And whatever we think we should do, can't we take a second look in 5 years or 10 years or 7 years? I think there's one way of lowering the sentences. There's another saying we must have a wise second look, because at the time of sentencing, we don't have an almighty, omniscient judge. We have flawed human beings that are react. Now, so that's the people in the system. I like your idea that you're care, not jail. And I will say, a woman who has been around she's now retired, Diane Cummings, she really knows this system as much as anybody. And she always repeated one thing: you build it and they will come. So if you create the jail cell, it will be filled up. So that gives some credence to this books, not bars idea. If you create it, they're going to come. So, but boy, don't want to take on too much here. You legislators, you got your hands full. And I want to say, by the way, when we got these enhancements, whether it was partially changing the felony murder rule or giving some discretion to the judge on the gun enhancement, we had to muscle that through. There was not enthusiasm in the Democratic liberal California legislature. They want to do a lot of quote, progressive stuff. But when it comes to dealing with violent criminals, I don't want to go through all the litany of bad crimes. They have a very low appetite for rationality, if I may say that.
Well,
You
I
don't
did
have
say
to-
that. No, I did say that Judge Espinosa was going to have the last word, but I'm going to take it. I just want to ask you actually about the biggest piece of reform that was enacted under your governorship, which was realignment. And you talked about the counties taking more responsibility here. I was wondering if you could just reflect a bit about, we heard some testimony in a previous hearing about how people actually have better outcomes having served their time in county jail versus state prison. And I was wondering if you could reflect on it. Was realignment a success? And should it be expanded? Should it be reformed? Or is it, I mean, I'm just curious about what your thoughts are about how that went out.
Well, I'll tell you, just to give you an idea how things go. Diane Cummings did some realignment under Pete Wilson, some of it to deal with welfare. She was really the architect of realignment. And I remember saying, as we were getting close to completion, I said, Diane, I hope the hell you know what you're doing. Because I didn't quite know what it is I had bought into. But it sounded good. It sounded good to me. I mean, actually, and because you're going to a more local decision making, and that there, I think there's more flexibility, there's more encounter with the real life experience, and there's more room for evolution and change. The legislature is more rigid. It takes more time to get a law. It takes even more time to get it undone. So the realignment had an idea, move things locally. I think that you can expand on that. But again, you've got to make sure that the local community has the wherewithal. At least the state can be more sophisticated. And I don't know what it is to be, I've been down to that downtown jail. I don't know if it's any better, but that does not look to me as good as San Quentin. Now, I'm not saying, you got to make the local a better opportunity, a better experience. I don't want to say experience, that's the word they use now, the shopping experience, the dining experience, and so there's the incarceration experience. So I don't want to make it too good, but you've got to make it so it achieves a human goal of protecting the community, inflicting whatever we have to do in our punitive ways, but leaving plenty of room for rehabilitation. And so I think, yeah, you can work on, it's a framework. You can do whatever you want. You're just advising. So look at it and don't think that whoever did it knew everything there was to do. I think you can look at it. I think probation in LA needs a lot of scrutiny if you're going to give them more work. So anyway, I do think locals, LA's so big, I think they have more difficulty. But yeah, add to realignment. Why not? But boy, you're going to be doing a lot of stuff on this penal review commission if you're going to take on realignment.
Well, you gave us a broad mandate, and we very much appreciate it, and we will do our best to do you proud. Thank you so much for your time this afternoon, Governor Brown. I promise to take you up on your offer for us to continue to pick your brain. So thank you very much. For the rest of the group, and have a good afternoon, Governor Brown. For the rest of the group, let's take a 5-minute break before we get on with our first panel. So let's get back on at, I think, 1:52. Thank you,
And
everyone.
thank you very much. You're doing the Lord's work. It's really profoundly important that you address issues that, for the most part, people want to turn their head away from. So thanks.
Thank you again, Governor.
Thank you, Governor Brown. Thank you.
Okay.
Thank you, Governor Brown.
Thank you. All right. Leave the meeting.
Okay, I think we're mostly back. Senator Skinner, are you there?
Yes, I'm here.
Terrific. Judge Espinoza and Judge Moreno. Justice Moreno, we're waiting for. Judge Espinoza. Oh, there you are. All right, I think we're all back. All right, with that appetizer, we're ready to move on to the main course, as it were. Today's topic is sentencing enhancements. As many as you know, there are more than 150 sentencing enhancements in California law. And this is a huge increase from when California first created sentencing enhancements in the 1970s. Since then, there have been only a handful of them. But now the law, at that time, there was only a handful of them. But now the law literally can't keep up. A catalog of enhancements was actually removed from the penal code because it proved impossible to actually maintain. We have very little idea, actually, of the costs or benefits of sentence enhancements to public safety in California, and that is something the committee is committed to investigating. However, we do know that some of the most heavily used enhancements appear to have severe disparate racial impacts. For example, of those people who have gang enhancements, 92% of them are Black or Latinx. People with gun enhancements in CDCR custody are more than 80% people of color. Those numbers are not surprising to many of us, but they are still shocking. Sentencing enhancements also appear to be a significant driver of mass incarceration. In 2016, 80% of people in California prison had at least one sentence enhancement. 25% had 3 or more sentence enhancements on their cases. As a basic idea, I think sentencing enhancements have some value. Fine-tuning a sentence based on the particular facts of an offense is not inherently a bad idea. But California's use of sentencing enhancements seems to have gone way beyond that, with some enhancements doubling, tripling, or even further enhancing a sentence for the underlying offense. So today we'll hear from prosecutors, public defenders about how enhancements work in practice. We'll also hear from people who have served or are serving long sentence enhancements. And we'll also hear from the Department of Corrections and Rehabilitation about special issues that people with serving those long sentences present to the prison system. One final note. Today's discussion will focus largely on sentence enhancements that can be changed with a majority vote in the legislature. That means that some of the most important sentencing enhancements in California, such as 3 strikes and the 5-year so-called nickel prior, won't be covered in tremendous detail because they are passed by initiative and realistically can only be reformed by initiative. These issues are they remain extremely important to us, and I hope the committee will be able to address them in the future. So with that said, I'd like to introduce our first panelists. We have a really stellar group of panelists today, and I want to give my deepest thanks for them sharing their time and insights with the committee today. Each panelist will have 5 minutes for opening remarks, and then we'll reserve the rest of the time for Q&A. Panelists, please know that we have read your submissions carefully. So in your opening remarks, please quickly hit the high points so we can begin to dig into the details as quickly as possible. Our first panel will give the committee an overview of sentence enhancement practice in California, including the perspective of a large prosecutor's office. We'll also hear about gun enhancements and a certain type of robbery offense called Estus Robberies, which essentially work as an enhancements. Our panelists are Robert Weisberg from Stanford Law School, Jeff Rosen, who's the District Attorney of Santa Clara County, and Lisa Roth, who's a public defender in Los Angeles County. Professor Weisberg, Bob, it's good to see you. We'll start with you.
Thank you, Michael, and thank you, everyone. The catalog of enhancements that Michael refers to is quite a document, or quite a set of documents. You have in the memo I submitted, but also in Tom Nozowitz's very useful summary memo, a glimpse of the complex spaghetti of these enhancements in California. I want to concentrate on the question of what they cost to offenders and to the state of California, but also what they present in terms of a kind of conceptual or process problem with how we conceive criminal justice. First, as noted in the materials you got, I was part of what turned out to be a very small study to see exactly the numbers and nature and consequences of enhancements in one jurisdiction, which is obviously not very, very representative, and that is San Francisco. This was the one opportunity we had to do a really, really high-end statistical analysis of how enhancements worked in a particular jurisdiction. And let me just emphasize the meta point here, which is that our difficulty in getting many, many counties, or actually anybody on one county, and even information from the courts, because the only data set we got was actually from a prosecutor, that underscores what I'll call the meta problem here. And that is, well, it's important that, as Michael noted, there is now some big CDCR aggregate data. We really have to know how enhancements are charged and executed in particular jurisdictions. And so my major takeaway, in a sense, is could we please have better data collection or data access in California so we can actually know what's going on? The specific question I was asked to address, and this was by the Chief Justice of California, was could we come up with any kind of estimate of the portion of the prison population which can be attributable to prison enhancements? Now, there's kind of a math problem here. What we wound up studying, of course, is time sentenced in a database of several thousand cases in San Francisco, projected time sentenced, allowing for the possibility of good time credits. So the predicted, fairly reliably predicted inflow or input of sentences is always going to have a complicated mathematical relationship to the size of the prison population at any one static point. Nevertheless, they're going to be interesting correlations. So just to say that our study led us to believe that 1/4 of the total years of imprisonment people were sentenced to during the 10-year period we looked at were attributable to enhancements. What that translates into in terms of, again, the static portion of the prison population is a complicated matter, but this would suggest, number one, it's not trivial. Number two, this was San Francisco, okay? Next, what was the distribution? Well, I think as Michael suggested, it's somewhat disproportionate. A large number, actually the majority, were 3 strikes and one of the prior crime enhancements. I want to be careful in making a distinction here, though, because I want to say a few words about what I'm calling the kind of conceptual jurisprudence of enhancements. The whole question of, to put the term more broadly, habitual offender laws it's a very complex subject, but that's subjected to a great deal of jurisprudential commentary, and indeed, as you know, some limited, but some constitutional control. In some ways, I think what's more interesting to get at the heart of the enhancements is to look at the different ones, particularly the one featured in the memo we handed out, which is guns with relation to robberies, and so on and so on, okay? Now, we know that a sentence for robbery will more than double with 2 of the commonest enhancements, the prior and the prior and the use of the gun for a robbery, okay? Compare that conceptually to a different scheme, and at Tom and Mike's suggestion, I looked at a different scheme, namely New York. California does not have an armed robbery statute. It's got a robbery statute with a typical triad, and then a potential for a humongous increase in sentence because of the gun. New York has an armed robbery statute, that's first-degree robbery, and a non-armed robbery statute, second degree. Their sentences are very high, although pretty indeterminate. Something like 15 to 25 for the higher one, 5 to 15 for the lower one. I would not argue that enhancement structure, as opposed to typical crime structure like New York, necessarily produces higher sentences. I don't know what the sentences are in New York for armed robbery compared to the effective armed robbery in California. But the question is, taking one state at a time, would we have different sentences if we had something like the New York model? I'm not sure, but I think the point is that the use of a gun in New York is part of, dare I say, a kind of holistic assessment of the sentence by the judge. It can be taken into account somewhat situationally. And how much the prosecutor in a New York discretionary sentencing process pushes the fact that the guy used a gun, hard to say, okay? In California, it's not part of a holistic process. It's an artificial add-on. And I assume, although we don't really have any way of proving this, I assume that it's much more likely to have a significant effect on the sentence simply because it's only going to be there in the case if the prosecutor chooses to charge the enhancement, which means that prosecutor isn't going to say, yeah, I'd like you to push this enhancement, but let's look at it a little more flexibly and holistically. That's not going to happen. Now, it's a very odd way to do business, and I'll just end on this point. There is a sense in which an enhancement of the kind I just suggested resembles the felony murder rule. Because let's face it, particularly with gun enhancements, which I found an interesting example, where we know that ironically, a lot of the push nationally for gun enhancements has come from the National Rifle Association, because that's their way of saying, we see we're getting the bad guys with the guns, not the good guys with the guns. So, you know, you got to be a little suspicious of some of the inputs. But if it is bad to use a gun, it should be bad to use, wield, carry, possess, brandish a gun. Maybe that should have a higher sentence. It only gets a much higher sentence if it happens to happen in the course of another crime, which means if the idea of the gun enhancement is to deter the use of guns, it's about as irrational a deterrence theory as is felony murder. You have a small chance of being busted for a robbery as opposed to just walking around with a gun. But if you get busted for a robbery, your gun offense is going to go up humongously. So there's a rather odd jurisprudence. And the last thing I'll say is the historical part of the jurisprudence is that, not that I have a romantic notion of how legislatures define a crime, but they have defined crimes, and then the crime du jour, or more appropriately, the enhancement du jour add-on by sometimes demagogic politicians, means that there is never any redeliberation of what the crime really is. Thanks.
Thank you very much, Bob. I'm going to turn it over now to DA Rosen. Thanks again for taking your time. I really appreciate your submission, and I'm curious to hear what you have to say.
Thank you very much. It's a pleasure to be with all of you. In 1999, very early in my career, I'd been a deputy DA for maybe 3 or 4 years at this point. I prosecuted my first 3 strikes case. The defendant was 24 at the time he was tried. His name was Kung Nguyen. And the jury convicted him of check forgery, possession of stolen property, and running from the police. Previously, he had been convicted of check forgery, residential burglary, and attempted residential burglary. I strongly advocated at the end of the trial for 27 years to life. And that's the sentence he got. The reason I tell this story is that's what we all knew would happen in that case. This was not his defense attorney wasn't surprised. This wasn't a hard issue for the judge to decide. It wasn't a particularly heavy sentencing judge that made this sentence. It was very much kind of a middle of the road judge. That's just how things were. Then I got elected DA and took office in 2011. And in 2012, I was one of 3 DAs, I think Steve Cooley was mentioned earlier, to support Proposition 36, which tightened up the 3 strikes law and made it so that that 3rd strike had to be a strike, a serious or a violent offense. But it also called for resentencing opportunities for those that had been convicted of non-violent 3rd strike offenses. And as a result of that, shortly after that, in 2013, Kung Nguyen was released from prison. He'd served about 15 years, and he's been crime-free ever since, as have the thousands of prisoners who were released after Prop 36. You know, Governor Brown talked about a little bit the power of ideas and the zeitgeist, and you know, the thinking in the 90s was much different, much more punitive and harsher, and not scientifically supported than the thinking is today. So I think that our current system in the penal code is very much a work in progress, but that means that over time, we've made so many amendments and changes that the time has come for reform that looks at the system as a whole. For example, Most felonies have a triad of potential sentences. You know, mitigated term 16 months, midterm 2 years, aggravated term 3 years. And our system does pretty well in appropriately filtering cases into the appropriate category, whether this is a midterm, a high term, or a mitigated term offense. However, the actual number of years attached to each category, in other words, is this a 1623 offense, a 246 offense, a 579 offense? That's completely made up. That's not based on science or anything empirical. It's just made up. And it's also, it sort of says, well, if robbery is worse than burglary, then whatever burglary is, robbery should be higher than that. And burglary is worse than regular theft, so we make burglary higher than theft. But who said why theft should be worth this much and not that much? Nobody. It just happened. So we need to look closely at the actual years associated with each crime to make sure it's backed up by sound research. So we are neither sentencing so lightly that there is no deterrence or no accountability, no justice, nor that we are sentencing so harshly that we just get diminishing returns and injustice, unfairness. I think that sentencing enhancements can serve a purpose as they distinguish between cases that might look alike on the surface. For example, who would doubt that a man who steals a bike should be treated differently than a man who steals a bike at gunpoint? However, the practical impact of enhancements has grown out of all proportion with their original intent. As I say, when I began as a prosecutor, enhancements could moderately shift the underlying sentence. Now they have become the tail that wags the dog. It's quite common now that the entire trial and all pretrial negotiations are solely about the enhancement, not about the crime itself. This creates multiple problems. It distorts the system. Without any conscious decision, we converted our objective triad system into a purely subjective probation life sentencing scheme for many defendants. In other words, as a society, we deliberately shifted so that judges didn't have complete discretion on every case, but were instead bound by a sentencing triad that needed factual evidence on the record for support if a judge was going to deviate from the midterm. The judge says nothing, it's the midterm sentence of the triad. The judge has to say something for it to be aggravated or say something for it to be mitigated. And of course, I know that there's other judges on this panel who are very well aware of that. But now with enhancements, cases are effectively returned to a 0 to life status, but without any oversight. This, of course, has racial justice implications because whenever we allow purely subjective decisions without transparency and oversight, implicit bias has an entrance into our system. So enhancements, what was meant to be the spice, has become the whole meal. So what are my suggestions? Limit the impact of enhancements. Perhaps limit enhancements for how they were before. Years and years ago, they were limited to double the base term, meaning in the example I gave earlier, if the offense was 16, 2, or 3, then whatever the enhancements are, the maximum offense could be 6 years, double the base term. That was the limit. So that in the end of the day, an individual is mainly punished for the crime that they committed, not the enhancement. Another idea, and these are ideas and suggestions that I have. Limit a case to 1 enhancement. For example, if a person used a gun while committing a robbery, while on parole, and within a few years of leaving prison, okay? So for those of you taking the law school exam at home, there's 3 different possible enhancements there. I know Professor Weisberg would spot them immediately, but there's the prison prior, there's committing the offense while you're on parole, and there's using a gun. 3 different enhancements. So 1 is you could say to the prosecutor, choose 1 of those enhancements. 3, put an upward limit on the maximum additional time any enhancement can impose. Really, these are 3 different suggestions that would be ways of limiting the impact of enhancements. One change that I've recently made in my office is to severely restrict the imposition of gang enhancements for misdemeanors, because the impact of that enhancement is to elevate a misdemeanor to a felony. Finally, I hope this commission can address the perverse economic incentives that encourages counties to send people to prison and discourages local solutions and probation. Now, earlier with Governor Brown, you were talking about realignment, which was an effort to have a greater category, a lot more offenders dealt with at the local level rather than the state level. See, today, if we in Santa Clara County divert someone from jail and give them drug treatment and job training, which we do, the county pays for the entire project. By contrast, if we send someone straight to prison, the state pays for the whole thing. This is incentivizing incarceration over local rehabilitation. And I hope the commission addresses this as well. So I think we need systemic reform. I hope the commission looks to find scientifically valid sentencing ranges rather than relying on the tradition that we inherited. And 3, while I think that enhancements play a vital role in distinguishing between cases, they're out of proportion, and there's different ways to try to limit enhancements. And finally, I think it's important to eliminate the distorting financial incentive where local rehabilitation is borne entirely by the county, but long prison incarceration is paid for by the state. Thank you very much.
Thank you very much, DA Rosen. Appreciate your time and look forward to, you brought up a lot of things that I want to ask you about. Finally, Lisa Roth from the Los Angeles Public Defender's Office. I'd like to hear from you too. You're on mute. You're on mute.
Sorry about that.
Sorry.
My name is Lisa Roth. I've been a public defender with Los Angeles County for almost 27 years. And at this point, I'm a grade 4 and have been for the last 15 years. So I can handle any type of case, including capital cases. So I feel as I've seen a lot during my 27 years. And I've been asked to talk about gun enhancements and Estus Robberies. Really 2 very different topics. And I know that you all have read, hopefully, my memo along with the committee summary. So I'm going to make my statements brief because they also kind of bounce off what you've already heard from Mr. Weisberg and DA Rosen. Essentially, as you just heard about gun enhancements, there's multiple different enhancements with varying different sentence schemes. The biggest problem that I can talk about in such a short time would be the section 12022.53, and that's the 10-20 life gun enhancement, which was enacted in 1997. When that was enacted, it did not remove. They still had the old enhancement, but what the 10-20 life did is obviously shift the type of sentence to one, definitely for prison, but also the fact that the minimum sentence someone would get would be 10 years plus whatever the crime, whatever sentencing scheme. So for a robbery, 2, 3, or 5, you all suddenly had somebody looking at a minimum of 12 years if they used a gun. Whereas before, in the old sentencing scheme, it was 3, 4, or 10. The other problems is if the gun was discharged, then you had 20 years that was added on, and if someone was injured, it would be life. I do talk a little bit about what I think the solution would be, and that would be to eliminate 12022.53 completely, because what you get is an 18-year-old, a 20-year-old commits a robbery with a gun, nobody's injured, and all of a sudden the minimum sentence they can get is 12 years. Obviously, the fact that it's a gun makes it prison. They must serve 85%, and it makes it very difficult to dispose the cases, because the amount of time they're facing, really, if they went to trial and were sentenced to the maximum time, would be 15 years. So oftentimes there wasn't a lot of wiggle room, and there wasn't a reason to dispose the case because they weren't facing that much more time. Something else that I think could be considered would be to make sure that if the weapon is used, that you can't use it on more than one count. So for instance, if there was 3 different charges of robbery in one occurrence, you can add the 10 years to each count, which would be 30 years just right there for a gun. So there's a lot to be said about the gun enhancements. I could go on and on. I think the main thing would be to eliminate 12022.53, go back to 12022.5, which has the 3, 4, or 10 enhancement, which would allow the judge to look at a case and then possibly even add another sentencing scheme to that, where you might add 1 year, so that they could look at, you know, the person's background and not have them serve such a substantial prison time. As far as Estus Robberies, basically what that is a shoplifting and where force or fear is used. So essentially someone commits some type of act in the store, they are leaving the store, a security guard confronts them, and they use some type of force, which can be as little as a push or a shove. It can be words. And a way around that would be to just eliminate Estus Robberies. It is incredibly, well, it disproportionately targets people of color, those who are impoverished, those who are under the influence of alcohol or narcotics, or the mentally ill. Oftentimes they're just stealing food or something along those lines. And oftentimes they're leaving the store and it's the security guard who's in plain clothes that attempts to stop them, and the force is used in order to get away. And again, it's usually something minor. The way to still punish somebody for using the force would be to charge them with the shoplifting, and you could also charge with a battery if in fact there was some type of shove. If there's words, you could charge them with some type of criminal threats, but I think it would be incumbent upon the people that are formulating the new penal codes to make sure that criminal threats could only be a misdemeanor, so that it would not be a strike, it would not be a felony, and it would allow for a shoplifting to remain a shoplifting and not a robbery, which as a robbery, a person is then receives a strike prior, which can be used in the future. It makes the case serious or makes the case violent, so they serve 85% time, and they also have to go to state prison versus being allowed to serve their time in a county jail. Again, that was 2 very different topics. I'm sorry if I jumped all over the place. I do want to alert you all, and then I will stop, that there was an arithmetic error on the handout that you received when I gave some examples of, on page, when I gave some examples of sentencing schemes, and that would be on page 3. I think you're going to get a new handout. The great bodily injury scheme that I discussed, I made an error and I was out of town, and so sorry that was not corrected prior to receiving the handouts. And thank you.
Thank you very much. I have a ton of questions. I'm sure the rest of the panel does too. I'm just going to start. I'm going to kick things off with DA Rosen, because you touched on something that actually came up with one of our prior meetings. You weren't around for, so you couldn't have known about, but I'm talking about the financial incentives piece of what you had talked about. And I was just wondering if you could talk for a few minutes about, from the DA's perspective on, I get in an abstract sense that there's these financial incentives to send people to state prison, but I don't understand how that actually plays out, right? I can't imagine that there's a line DA that's sitting there that says, like, if I send this guy to state prison, then somehow that's going to save the county budget, and that's going to somehow be a benefit to me. Same thing for the judge. I can't imagine the judge is really sitting there and scratching his or her head and being like, well, I'll get more salary. That just doesn't seem plausible on one hand, yet at the same time, we've seen it play out in different circumstances. So can you just explain how that works, or what's your perspective on that? Do you get what I'm asking?
I do. Yeah, Michael, I do understand what you're asking, and I agree that, no, I don't think it happens that a line DA says, if I advocate for prison, there's going to be more money for my salary next year, or something like that, or a judge does that. I don't think it happens that way. But what I do think happens is, let's just say you have a DA that's, I'm real tough, I'm law and order, and the way I'm going to show how tough I am is I'm going to send a lot of people to prison. And if the county that DA was, okay, I'm going to send people to prison. That's what I'm going to do. And everyone in the county who votes for this DA can feel like, yeah, we're tough on crime. Yeah, okay. It's the counties that pay for that are not those rural tough on crime counties. They're not paying for it. My county's paying for it, Santa Clara County. That's my county, and other wealthy counties are actually paying for that. If you said to that DA, well, look, given the size of your population and your crime rates, you can send between X and Y number of people to prison in a year. There's sort of a range you should have. You can be tough, but here's the range. Over and above that, your county's going to pay for it. If a county board of supervisors had less money to spend on the things that it wants to spend money, I mean, it may choose, fine, we'll spend money sending people to state prison. I doubt it. If they have less money to spend, they're going to be upset with the DA for doing that. So I think what happens is the costs of that incarceration are not felt locally by the local elected officials. And if those costs were felt locally, those elected officials would act differently. That board of supervisors might give the DA's office less money because the DA's office is costing it a lot of money by sending people to prison that it really doesn't need to send to prison. So I don't think it happens at the level of an individual DA or an individual judge. I think it happens more at the level of the elected DA, to be quite frank, and directing, whether a lot of people are going to be sent to prison or not, because it's not something that has any economic consequence to that DA. And by the way, the notion of economic consequences to our decisions, I think, is a very important one. We have very little feedback economically on anything that happens. And a prime example, and I know you didn't ask me this, but I really think it's important to say, if somebody goes to prison, what incentive does the prison have to rehabilitate that person? If the person gets out and commits a crime, it's not like the warden's salary's cut, the correctional officers make less money. No disincentive. What if there was an incentive for the prisons and the people that worked at them to really try to rehabilitate people? Hey, if every person who gets out doesn't commit a crime for 5 years, you might get a bonus. There's a way, money's a very important thing in our society, and it seems that we can use it to incentivize the kinds of results that we would like. And so those are my 2.5 cents.
Thank you very much. Other folks have questions? I know you do. Senator Skinner? You're on.
This is to anyone in our panel. So, okay. DA Rosen, what you just expressed about the economic incentive, and as you know, it goes beyond counties. In effect, it's all California taxpayers are subsidizing. If we look at the incarceration rate per capita of certain counties versus others, and the cost to California for holding someone in prison, we do not, there's no economic logic to how we do it at all. There's no rationality. So I really appreciate your pointing that out. And I guess if the legislature or if the Penal Code Review Commission were to recommend that there be some economic signals like that, do you think the DA Association would embrace that? Or would that be something where, because, if you have 54 members, unfortunately, majority of them are the smaller counties because there's more small counties than the big ones, would they reject that?
I think the thinking of a lot of elected DAs has changed over time. It may not have changed as quickly as some of the legislature would like it to change, but I think attitudes are changing. And I think that for counties that are poorer, if there was some state assistance in helping them have programs that they could use in their jails to rehabilitate people, whether it's drug treatment or mental health treatment, I would think they would embrace that. I think that can be done cheaper than incarceration in the state. And it's not just about money, but it's also in a way that still would maintain fairness and justice. You know, we just have a sense that while I said I don't know that I can say exactly what the right number somebody should get for robbery is. I know robbery is more serious than burglary, but so in some sense, I almost think what the commission might want to consider is, what if we just reduce sentences across the board 20%? You know, just every case was worth 20% less. You would still have the same relationship between the crimes, which I think is important, but you would just kind of ratchet it all down a little bit. That's one way to approach it. I think what Governor Brown was talking about is by providing for more early parole opportunities, you can shorten sentences at that end also. And I do think there's a strong logic to doing it that way. And the reason I think there's a strong logic to doing it at the parole level, at the parole end of the spectrum is, look, as a DA, I can tell you what this person did at this moment in time. And this was a very serious crime, and it tore up the community, and it was terrible for the victim, and it caused a lot of lasting damage. And the judge at the time can say, this was a terrible thing that this person did. Absolutely. But 10 years from now, 15 years from now, I can't tell you if this is the same person that I prosecuted, and the judge can't tell you that. We're not equipped for that. But I think it's appropriate for, you know, a parole board to have the ability to see if this person has rehabilitated themselves. And as the governor pointed out, there's not always a relationship between how serious the crime committed was and whether the person's rehabilitated themselves.
Right, right.
So I think that those are good things for a parole board to look at. But I just would say that I do think that while, you know, not every DA in the state agrees with my philosophy about things, I do think that in general, every DA in the state has moved left over the last 5 to 10 years. Maybe not as left as some would like, but they're definitely moved in that direction. Everyone has.
So one quick comment, Mike. Your point about also the perverse incentive that we provide an incentive through realignment to, in effect, cover the jail costs. We don't necessarily provide the incentive for doing the say diversion, the complete rehab. And at least the data I've seen shows that in most counties, that type of diversion type of program or rehab program is far less money. It costs far, far less than either jail time or prison time. So I think I think we should look at some of that. It's worth looking at.
Michael, may I add something?
Yes, sorry, I was on mute. Carlos, of course.
I'm sorry. Yeah.
Oh, I'm sorry, Bob.
Yes, sir.
I'll defer. I'll defer to
And
counsel.
I'll defer.
So let's go first to Professor Weisberg and then Justice Moreno.
Just a small point to augment what Senator Skinner said and what DA Rosen has said. Just want to mention a great piece of scholarship done a few years back by my good friend, Professor David Ball of Santa Clara, who's one of the great scholars of criminal justice in California. It's called Tough on Crime on the State's Dime. And it preceded realignment, but it was actually around the time of but let me clarify that. It was sparked by the problem that the original funding dispersal from the state to the counties for realignment, it changed a lot, it became more sensible, was proportionate to the percentage or the proportion of state prison inmates who came from that county. In other words, it was a replacement. And David pointed out beautifully, after a brilliant statistical analysis that talk about perverse incentives, it turns out that there was no correlation between the actual crime rates of violent crime rates in those in the counties and their contribution to the prison. It had a lot to do with attitudes about punitiveness, which means it was a terrible reinforcement of negative externalities. And that's why I appreciate the argument that, to use some economics that I don't fully understand, cost internalization is a wonderful idea here. Thanks.
Thank you, Bob.